Rule 16. Preventive suspension. Section 1. Preventive suspension of the respondent by the disciplinary authority or IAS. The concerned disciplinary authority or IAS, upon motion of the complainant may, at any time after a case is formally filed but before the submission of the complainant's position paper or conduct of clarificatory hearing, place the respondent/S on preventive suspension for a period not exceeding 90 days under the following circumstances. That the charge is serious or grave and the evidence of guilt is strong, or there is evidence to show that the respondent is exerting efforts to harass, intimidate, coerce, or unduly influence the complainant or his/her witnesses into withdrawing the complaint or retracting the sworn statement against the respondent or to tamper with the evidence. Section 2. Request for preventive suspension by the PLEB. In the following cases, the superior officer shall not deny a request for preventive suspension by the PLEB. When the respondent refuses to heed the pleb's summons or subpoena. When the P&P personnel is charged with offenses involving bodily harm or grave threats. When the respondent is in a position to tamper with the evidence, and when the respondent is in a position to unduly influence the witnesses. Any superior who fails to act on any request for preventive suspension without valid grounds shall be held administratively liable for serious neglect of duty. Section 3. Motion for reconsideration on the order of preventive suspension. The respondent/S may file a motion for reconsideration with the disciplinary authority within 5 days from receipt of a copy of the order of preventive suspension anchored on the ground that the order is not supported by any of the circumstances enumerated in sections 1 and 2 of this rule. Rule 17. Summary proceeding and disposition of cases. Section 1. Summons. The designated summary hearing officer or the PLEB shall issue summons within 3 days from receipt or docketing of the complaint, as the case may be, to be served upon the respondent directing him/her to submit his/her answer within an inextendable period of 7 working days from receipt thereof. Section 2. Answer. The answer shall be in writing, under oath, and must contain material facts, which may either be a specific denial or affirmation of the allegations in the complaint as well as the presence of mitigating circumstance/S, if any. The respondent/S may attach therewith documentary evidence in support of his defense, copy furnished the complainant. The answer shall be filed either personally or by registered mail, with proof of appropriate service to the complainant. If the answer is sent by registered mail, it is deemed filed on the date of receipt stamped by the post office on the envelope. Said envelope shall be kept and made an integral part of the answer and records of the case. The disciplinary authority shall not entertain request for clarification, bill of particulars, motion to dismiss, and any other motion which are obviously designed to delay the administrative proceedings. If any of these pleadings are filed by the respondent, the same shall not toll the reglementary period for filing an answer. Section 3. Effective of failure/refusal to file answer. If the respondent fails or refuses to file an answer within the period provided, she shall be considered to have waived his/her right to submit the same, and the case shall be decided based on available records. Section 4. Effective admission by respondent. When the respondent in his answer admits his culpability to the charge, the PLEB or the summary hearing officer shall determine the penalty commensurate to the offense committed, taking into account the presence of mitigating circumstance/S invoked by the respondent and aggravating circumstance/S alleged by the prosecution. Section 5. Pre-hearing conference. Within 15 days from receipt of the answer, the PLEB or the summary hearing officer shall conduct the pre-hearing conference for the purpose of a. Defining and simplifying the issues of Th2 case, b. Entering into admissions and/or stipulation of facts, c. Marking of exhibits after proper identification by the parties/signatories, and d. Threshing out other matters relevant to the case. The proceedings in the pre-hearing conference shall be recorded duly signed by the parties and summary hearing officer or PLEB. Section 6. Submission of position papers. The PLEB or the summary hearing officer shall direct the parties to file, within 15 days from the termination of the pre-hearing conference, their respective verified position papers in lieu of a full-blown hearing, taking into account the summary nature of administrative proceedings. The position papers shall contain only those charges, defenses, and other claims contained in the affidavits and pleadings filed by the parties. Any additional relevant affidavits and/or documentary evidence may be attached by the parties to their position papers. Upon receipt of the position papers, affidavits, and other pleadings filed, the PLEB or the summary hearing officer may consider the case submitted for resolution. The failure of any party to submit position papers shall be considered as a waiver thereof. Section 7. Clarificatory hearing. Within 5 days from receipt of the position paper of the parties or after the explanation of the period to file the same, a party may move or the summary hearing officer or the PLEB may issue an order for the conduct of a one-time clarificatory hearing where the parties shall be afforded the opportunity to be present and submit written clarificatory questions to the summary hearing officer or the PLEB, which will determine whether or not the questions are necessary and relevant to the fact in issue. Thereafter, the parties may submit their respective proposed draft decision for the consideration of the summary hearing officer or the PLEB in arriving at its findings and conclusions. The failure of any party co-submit the same shall be deemed a waiver thereof. Section 8. Assistance of counsel. Parties may be assisted by counsel in the preparation and submission of their pleadings and during the clarificatory hearing. Section 9. Postponement. Request for postponement of a clarificatory hearing may be granted only in meritorious cases, such as illness of a party or his/her witnesses and or other similar unavoidable causes. A request for postponement on the ground of illness shall be supported by a duly sworn medical certificate. Regardless of the ground invoked, only one postponement shall be granted to each of the parties. Section 10. Prohibition on reassignment of respondent during the pendency of an administrative case. A respondent PNP member shall not be reassigned or transferred to another city/municipal police station or unit during the pendency of the case, unless the concerned disciplinary authority or IAS certifies that the presence of the respondent is no longer necessary. Any superior who knowingly violates this provision shall be administratively liable for irregularity in the performance of duty. Section 11. Effect of compulsory retirement. The compulsory retirement of the respondent shall not affect the pendency of his/her administrative case, and the award of retirement benefits due him/her shall be subject to the final disposition of the administrative case. The administrative case of a retiring or retired PNP member shall be terminated or resolved within 3 months from the effectivity date of his/her retirement. After the lapse of such period and the case has not been terminated or resolved without justifiable reason/SN or without fault or delay attributable to the retired PNP member, the retirement benefits shall be immediately released to him/her without prejudice to the outcome of the case. In the event that the respondent who was retired is found guilty and the penalty of suspension is imposed, the corresponding amount relative to the period of suspension shall be deducted from that portion of his retirement benefits that are allowed by law. Section 12. Effect of death. The administrative case against the respondent who dies during the pendency thereof must be resolved as follows. In situations where death occurred while the case is pending investigation, the administrative case should not be dismissed when the death of the respondent occurred when the formal investigation reached the stage where respondent is considered to have been afforded due process, as when the following concur: 1. Respondent was notified of the complaint/charge against him/her, and 2. When he has filed an answer or has waived his/her right to file the same, as this is the stage when respondent has been afforded the opportunity to explain his/her side. If the respondent dies before she could explain his/her side through an answer complaint/charge, the administrative case shall be dismissed on account of the death of the respondent, as she cannot be deemed to have been accorded the opportunity to be heard, which is a basic element of due process. In situations where the death occurred after the respondent has perfected his/her appeal before the appellate body, the appeal shall continue until its final determination. In the event the deceased respondent appellant wins the appeal, material and/or pecuniary benefits arising from the case, shall accrue to the legal heirs of the deceased respondent appellant subject to the law on succession. Section 13. Records of proceedings. The proceedings during the conduct of the clarificatory hearing shall be taken in shorthand or stenotype, if there is a stenographer. The stenographer shall immediately transcribe the transcript of stenographic notes taken, but in no case beyond 10 days from the date of the clarificatory hearing. Section 14. Where services of stenographer are not available. In areas and cases where the services of a stenographer are not available, a substantial account of the proceedings duly certified to as correct by the disciplinary authority or summary hearing officer shall suffice. Section 15. Submission of report of investigation. The summary hearing officer, whenever applicable, is required to submit a report of investigation within 30 days from the date the case is submitted for resolution, which shall contain the findings of facts and the corresponding recommendation accompanied by the complete original records. LN cases filed before the IAS, the Provincial Director, Regional Director, and the Inspector General shall resolve and forward its recommendation to the disciplinary authority, within 30 days from receipt of the report of investigation from the summary hearing officer. Section 16. Period to render decision. The disciplinary authority shall decide the case within 30 days from receipt of the report of investigation, or AS resolution. With regard to the PLEB, each case shall be decided within 60 days from the time the case is filed before it. Section 17. Contents of decision. The decision shall contain the full name of the parties, rank and assignment of the respondent, the offense charged, a brief statement of the material and relevant facts, the findings as established by the evidence on record, the conclusion, the applicable laws, rules and regulations, jurisprudence, and the disposition thereof. Section 18. Respondent found liable for an offense separate and distinct from which he was charged. A respondent may be found culpable of an offense separate and distinct from that which he was charged, provided that the acts constituting the offense of which he was found culpable were alleged in the complaint and the respondent was given the opportunity to answer. Section 19. Finality of decision. The disciplinary action imposed upon a member of the PNP shall be final and executory, provided that a disciplinary action imposed by the PNP Regional Director or by the PLEB involving demotion or dismissal from the service may be appealed to the RAB within 10 days from receipt of the copy of the notice of decision, provided, further, that the disciplinary action imposed by the chief of the PNP involving demotion or dismissal may be appealed to the NAB within 10 days from receipt thereof. Section 20. Motion for reconsideration. The party adversely affected by the decision may file a motion for reconsideration with the disciplinary authority which rendered the same within 10 days from receipt of a copy thereof based on any of the following grounds. Newly discovered evidence which, if presented, would materially affect the decision rendered, or errors of law or irregularities have been committed prejudicial to the substantial rights and interest of the movant, or the decision is not supported by the evidence on record. A motion for extension of time to file a motion for reconsideration shall not be allowed. The filing of a timely motion for reconsideration shall stay the implementation of the decision sought to be reconsidered. Only one motion for reconsideration shall be allowed, and the same shall be considered and decided by the disciplinary authority within 15 days from receipt thereof. Section 21. Certificate of finality. The disciplinary authority or appellate body shall issue a certificate of finality of the decision or resolution finally disposing of the case where no motion for reconsideration or appeal is filed within the prescribed period. Rule 18. Service of notices and summons. Section 1. To whom and by whom served, a. All notices and summons shall be served to the respondent in person by the process server or by registered mail at his/her official station/last known place of assignment or last known address as stated in his/her personal data sheet. B. If personal service is not possible or when the respondent refuses to receive the notices or summons, service may be made by leaving a copy of the same with the administrative officer at his official station or with any responsible member of respondent's household at his last known address, provided that if the latter also refuses to receive the summons or notices, service may be made to the official of the barangay office in that area. In all instances, a return of service by the server shall be made within 24 hours from service to the respondent, either personally or by registered mail. Section 2. Responsibility of the administrative/personnel officer. The administrative/personnel officer of a unit, office, or station shall compile and keep a complete record of the latest official residential addresses of all the PNP uniformed personnel assigned within his area of responsibility, and shall certify the latest official residential address of any respondent, upon presentation of the process server of the notices and summons to be served. Rule 19. Filing and service of pleadings, processes, and decisions. Section 1. Filing of pleadings. The filing of pleadings by the parties shall be made by presenting the original copies thereof to the concerned disciplinary authority, IAS, or appellate body, or by sending them by registered mail with proof that the other party was served with a copy. The date and time of the receipt shall be indicated on the face of the original document and the receiving copies. In case the documents were sent by registered mail, the date and time of actual receipt shall be the time and date of receipt as stamped on the envelope which is required to be attached to the document as pan of the record. Section 2. Service of subpoenas and interlocutory orders. Subpoenas and other interlocutory orders shall be served personally in the manner provided for under Rule 18 hereof, provided however, that if the complainant and/or respondent is represented by counsel, service of orders to the counsel shall be deemed service to his client. Section 3. Service of final orders/decisions I resolutions. Final orders, decisions or resolutions shall be docketed before its release by the disciplinary authority, IAS or appellate body, and copies thereof shall be served upon the parties personally or by registered mail. Section 4. Implementation of orders/decisions/resolutions which have become final and executory. Orders, decisions or resolutions which have become final and executory shall be referred to the P&P regional director or his equivalent supervisor in the office/unit where the respondent is assigned or the director, Directorate for Personnel and Records Management, Attention, Discipline, Law and Order Division, for implementation within 5 days from receipt of the request or order of the disciplinary authority or appellate body to implement the same. Copy furnished the Director, P&P. Finance Service and the Respondent's Unit Assignment. The P&P official to whom it is addressed must make the appropriate return to the disciplinary authority or appellate body indicating the action taken on the referral/order for implementation. Any P&P officer charged with the implementation of a decision which has become final and executory who fails to implement the same shall be liable for serious neglect of duty. Section 5. Maintenance of a docket book. A docket book shall be maintained by the disciplinary authority or lawson shall contain, among others, the following: a. Date and time of receipt of the pre-charge investigation report. B. The case number. C. The name of the parties. D. The offense charged. E. The summary hearing officer to whom it was assigned. F. The date and time of receipt of the case folder by the summary hearing officer. G. The date and time the report of investigation of the summary hearing officer was received by the disciplinary authority or IAS. H. The date the decision was promulgated by the disciplinary authority. I. The date the decision was received by the parties. J. The date the decision became final and the issuance of the certificate of finality. K. The date the implementing order was issued. 1. The date the motion for reconsideration, if any, was received by the disciplinary authority. M. The date the motion for reconsideration, if any, was resolved by the disciplinary authority. N. The date the notice of appeal, if any, was received by the disciplinary authority. And O. Other matters relevant to the case. Rule 20. Appeal. Section 1. How appeal is taken, time of filing. Appeals from the decisions of the disciplinary authority or appellate body shall be taken by the party adversely affected by filing a notice of appeal with the office that rendered the decision or resolution. Copy furnished the other party, within 10 days from receipt of a copy of the decision. Section 2. Appeal fee. The appellant shall pay the prescribed appeal fee, whenever required, and the proof of payment thereof shall be attached to the notice of appeal. Section 3. Notice of appeal and memorandum on appeal. A notice of appeal shall be filed in three legible copies which shall contain the following: 1. The material dates showing that it was filed on time. 2. The assignment of the specific errors of fact or law, or both, allegedly committed by the disciplinary authority. 3. The specific appellate body to which the appeal is being taken. And 4. The complete mailing address and contact information of the appellant or counsel. The appellant shall submit a memorandum on appeal in three legible copies simultaneous with the notice of appeal or not later than 15 days from the filing of the notice of appeal. Copy furnished the other party. B. In all appeal cases, the title of the case shall remain as it was before the disciplinary authority with the party appealing the case referred to as the appellant and the prevailing party as the appellee. Section 4. Dismissal of the appeal. When the appellant fails to comply with the requirements provided in sections 1, 2, and 3a of this rule, the appellate body shall direct compliance thereof within 10 days from receipt of the order with a warning that non-compliance with the requirements shall be construed as failure to perfect an appeal and shall cause the dismissal of the appeal with prejudice to its refiling. Section 5. Transmittal of the records. Within 15 days from receipt of the notice of appeal, the concerned disciplinary authority shall forward the complete original records of the case to the appellate body, which shall be systematically and chronologically arranged, paged, and securely bound to prevent loss of any piece of document and evidence thereof. The transmittal of the records shall be a ministerial duty, and failure to forward the same shall be a ground for administrative action against the concerned official or personnel for serious neglect of duty. Section 6. Docketing of appealed cases. Upon receipt of the complete original records, which shall include the exhibits and transcript of stenographic notes from the disciplinary authority, the appellate body shall immediately docket the same by stamping the time and date of receipt on its cover, assigning the appeal case number and entering the same, including its original administrative case number, on the docket book for appealed cases. Section 7. Period to act on appeal. The RAB and the NAB shall decide the appeal within 60 days from receipt of the complete records of the case. Section 8. Withdrawal of appeal. At any time before the appellate body renders its decision resolving the appeal, the appellant, as a matter of right, can withdraw the same, which shall consequently render the appealed decision final and executory. No motion to reinstate the appeal shall be allowed. Part 3. Administrative offenses and penalties. Rule 21. Offenses. Section 1. Offenses punishable. The following are the offenses punishable and defined as follows. Neglect of duty or nonfeasance is the omission or refusal, without sufficient excuse, to perform an act or duty, which it was the peace officer's legal obligation to perform, implies a duty as well as its breach, and the fact can never be found in the absence of duty. Irregularities in the performance of duty or misfeasance is the improper performance of some act which might lawfully be done. Misconduct or malfeasance is any wrongful, improper, or unlawful conduct motivated by premeditated, obstinate, or intentional purpose. It usually refers to transgression of some established and definite rule of action, where no discretion is left except where necessity may demand. It does not necessarily imply corruption or criminal intention. Dishonesty is the concealment or distortion of truth in a matter of fact relevant to one's office or connected with the performance of his duties. Conduct unbecoming of a police officer. Any act or behavior of a police officer, irrespective of rank, done in his official or private capacity which, in dishonoring or disgracing himself as a police officer, seriously compromises his character and standing in the PNP in such a manner as to indicate vitiated or corrupt state of moral character which shows his unworthiness to remain in the police service. Incompetence is ignorance or the material lack of adequate ability and fitness for the satisfactory performance of police duties. This refers to any physical, intellectual, psychological, and moral quality, the lack of which substantially incapacitates a person to perform the duties of a police officer. Oppression imports an act of cruelty, severity, unlawful exaction, domination, or excessive use of authority. The exercise of unlawful powers or other means, in depriving an individual of his property or liberty against his will, is generally an act of oppression, and disloyalty to the government consists of the abandonment or renunciation of one's loyalty to the government of the Republic of the Philippines, or advocating the overthrow of the government, through overt or covert acts. Section 2. Classification of offenses. For purposes of determining jurisdiction and applying the appropriate penalty, administrative offenses are classified into light, less grave, and grave. Light offenses. Simple neglect of duty shall include but not limited to the following. Fail to supervise, inspect, and control subordinates directly under his command as to their punctuality, attendance, prescribed attire, proper use and maintenance of equipment, preparation and submission of reports, efficient performance of their duties and responsibilities, and the observance of good order, conduct, behavior, and discipline. Fail to take corrective action by way of warning, advise or admonition to a subordinate or to report a subordinate who committed a dereliction, irregularity, or violation of departmental rules and regulations. Fail to order or cause the investigation of a subordinate reported to him as absent without leave. Fail to disseminate any order, directive, or instruction. Fail to coordinate or cooperate with other law enforcement agencies and their personnel. Absent oneself from office without having filed the necessary application for leave or secured the approval of the superior officer for a period not exceeding 3 days in a month. Fail or refuse to give his name and badge number when properly requested. Fail to report upon declaration of alert levels. Fail to report for duty in prescribed uniform with badge, identification card, service firearm, and other required equipment, except those not required to wear the prescribed uniform by reason of the exigency of the service. Fail to keep an official appointment with a complainant, informer, or crime witnesses without lawful justification. Fail to submit a written report to his superior officer immediately or within a reasonable time after accidental firing of his firearm, when time and circumstances would permit. Fail to take custody of government-issued property from a member under his supervision who is suspended, separated, retired, or dead. Fail to conduct within a reasonable period, proper, thorough, and complete investigation when assigned to do so. Fail to thoroughly search for, collect, preserve, and identify evidence in any arrest or investigation conducted by him. Fail to take proper custody, record, tag, and identify property entrusted to him as evidence. Fail to report to his superior officer his inability or incapability to report for duty, attend a conference, general inspection, or participate in an operation. Fail to respond to a call for assistance. Fail to inform his superior as to the result of action taken on a call or dispatch. Fail to report to his Sup 1 higher officer a hazardous condition or dangerous situation. Fail to prepare and submit properly written reports within the prescribed period. Fail to report to a new assignment within 10 days from the order of reassignment without sufficient reason. Leave his post or beat before the end of tour of duty or leave without the required turnover to the incoming duty personnel, and any other omission or refusal, without sufficient excuse, to perform an act or duty that is analogous to the foregoing. Simple irregularity in the performance of duty shall include but not limited to the following. Drive a marked police vehicle while not in prescribed uniform, except those who are not required to do so by reason of the exigency of the service. Use siren while not responding to an emergency or not in hot pursuit of a fleeing criminal or law violator. Malinger, loaf, or consort with others while on duty or arrange with another member to take his place during his tour of duty, without prior approval of his superior. Allow unauthorized member of the P&P to drive marked or unmarked police vehicles. Interfere or obstruct the work of other members or change the assignment or tour of duty of subordinates not belonging to his unit/office. Be delayed unnecessarily in attending to or in performing a duty. Delay in responding to a call for assistance. Any other improper performance of an act or duty chat one's analogous to the foregoing. Simple misconduct shall include but not limited to the following. Fail to salute officials, dignitaries, superior officers, and other officials entitled thereto or the national colors during the playing of the national anthem. Fight, threaten, or quarrel with any member of the police force, provided that when the member being challenged or threatened is one of higher rank, the charge shall be that of grave misconduct. Read newspaper, books, or periodicals while in uniform and on street duty. Be untidy or couch in his personal appearance and behave in an ungentlemanly or undignified manner. Fail to recognize and satisfy any just debt due to a private individual. Solicit attorneys, bondsmen, or guarantors for arrested or confined persons. Fail to be home or to be at the place of confinement without legitimate reason after having been reported sick or suffering injuries. Use rude or insulting language or exhibit similar rudeness to the public. Fail to report for record with the complaint or desk officer a case prior to its investigation. Allow or tolerate idlers, fixers, or persons of questionable character to stay or loiter in his office, post, or place of assignment without any legitimate reason or purpose. Fail to maintain cleanliness and orderliness in his office, premises, post, or surroundings. Use official forms, letterheads, seals, and stamps privately or in violation of protocol, provided that when they are used for committing fraud or dishonesty, the charge shall be grave misconduct. Be found to have the odor or smell of alcohol on his breath while on duty, or possesses alcoholic beverages on his person, police vehicle, post, or office. Make or conduct unauthorized solicitations of contributions from subordinates or private person, and commit any act or omission that constitutes a crime punishable under the revised penal code or special laws where the duration of the imposable penalty is imprisonment of 1 day to 30 days. Simple dishonesty includes a. Dishonest acts that did not cause damage or prejudice to the government as well as those with no direct relation to or do not involve the duties and responsibilities of the respondent. B. Dishonest acts that did not result in any gain or benefit to the offender, and where the information falsified is not related to employment in case of falsification of official document. Less grave offenses. Less grave neglect of duty shall include but not limited to the following. Fail to execute lawful orders from higher authority or tolerate any subordinate to ignore or ridicule any order, rule, or regulation. Fail to make immediate correction or take appropriate action when a dereliction, irregularity, or violation of law or duty is being committed or has been committed in his presence by a subordinate under his command, or fail to report the same to his commanding officer within 24 hours. Fail to take disciplinary action as may be necessary against a subordinate under his command who has committed a serious dereliction, violation, or irregularity. Fail to comply with any lawful order or instruction of a superior officer or the chief of police. Fail to report immediately to his superior officer, or to the chief of police the injury, illness, death, or escape of a prisoner who is under his custody. Fail to command W1IK to the chief of police, through channels, any valuable information that will lead to the apprehension of a wanted person, or furnish clues for the solution of a case or for the recovery of stolen property. Fail to issue a traffic citation ticket, TCT, or temporary operator's permit, TOP, to an offending driver whose license is already confiscated. Fail to turn in the used TCT or TOP together with confiscated driver's license at the end of his tour of duty or within 24 hours, or fail to account for the TCTs or TOPs issued to and used by him. Fail to report as a peace officer any incident, condition, or occurrence witnessed by or reported to him which calls for immediate police action. Fail to properly patrol his beat, sector, or post. Fail to take appropriate action concerning vice conditions in his beat and or give written report of the same to his superior. Fail to report to his superior officer, within a reasonable period, injury inflicted by him to a person or animal, damage or loss of government property while on or off duty. Fail to comply with the order of a court of competent jurisdiction. Willfully violate office regulations and or refuse or neglect to comply with said provisions. Sleep on his post while performing patrol or guard duty. Absent oneself from office without having filed the necessary application leave or secured the approval of the superior officer for a period of more than 3 days but not exceeding 15 days. Less grave irregularity in the performance of duty shall include but not limited to the following. Apply for and serve a search or seizure warrant in any establishment or private house without the knowledge or approval of the chief of police or his superior officer. Use traffic violation reports which are not duly validated by the Land Transportation Office, LTO, or the Metro Manila Development Authority, MMDA, or the city or municipal government. Use traffic violation reports duly validated by the LTO, MMDA, or city/municipal government but are not issued to him for traffic enforcement work. Use the official insignia, markings and seal of the police force in any privately owned vehicle, without the authority of the chief of police or superior officer. Disregard or violate traffic rules and regulations while driving a police vehicle when not in hot pursuit and not responding to an emergency call. Less grave misconduct shall include, but not limited to the following. Take advantage of his position by procuring goods and commodities at a losing price to an unwilling seller, or partake of food, drinks, and cigarettes free of charge. Engage in regulated gambling or games of chance, while on duty. Be drunk and disorderly while on or off duty and in recognizable police uniform. Maliciously intrigue against the honor of a co-officer, or indulge in idle gossip or spread rumors that tend to discredit a PNP member. Serve as escort or security officer, whether on foot or by motor vehicle, for any private individual regardless of his status in social or religious circles on any occasion, unless authorized by the chief of police or the appropriate officials authorized to do so. Take a trip abroad without approved leave and approval of the authorities concerned. Borrow or solicit money or any valuable from his subordinates unless the latter is engaged in the lending business. Commit any act or omission that constitutes a crime punishable under the revised penal code or special laws where the duration of the imposable penalty is imprisonment of 1 month and 1 day to 6 months. Less grave dishonesty involves circumstances wherein the dishonest act caused damage and prejudice to the government that is not so serious as to qualify under grave dishonesty, and wherein the respondent did not take advantage of his or her position in committing the dishonest act. Grave offenses. Grave neglect of duty shall include but not limited to the following. Fail or refuse to take command in an emergency in order to carry out police duty, being the officer present with the highest rank, grade, or position. Fail to prevent or suppress the criminal act of a subordinate being committed in his presence, or fail to report the same to the Chief of Police within 24 hours, 24, after discovery. Fail to apprehend and/or arrest a person under circumstances where it is his duty to do so. Fail to return personal effects of released prisoners or other property used as evidence, the release of which is ordered by competent authority or court. Fail to perform his assigned mission or fail to participate in an operation for the security of the President, or other high-ranking officials of the Philippines or foreign heads of state. Fail to administer first aid when able and/or convey to the hospitals, victims of traffic accidents, persons shot or stabbed, persons electrocuted, and others who are dying and in need of urgent medical or surgical attention. Fail to quell a disturbance or to protect a person from death or injury when able to do so. Fail to help a brother peace officer in apprehending or arresting a violator who resists, or in subduing one assaulting the arresting officer, or in disarming an armed violator, or in coming to the succor of another officer who is wounded, injured, or outnumbered. Fail to appear and testify, without justifiable excuse, in court, prosecutor's office, the PNP disciplinary authorities, appellate bodies, the IAS, or any other quasi-judicial body when duly notified or subpoenaed as witness. If his non-appearance resulted in the dismissal of the case or the acquittal of the accused, or when he is the principal witness or the arresting officer, the penalty of dismissal from the service shall be imposed. Absent oneself from office without having filed the necessary application for leave or secured approval of the authorized official for a period of more than 15 days prior to the enjoyment of the leave. Grave irregularity in the performance of duty shall include but not be limited to the following. Act as bodyguard or security guard for any public official or candidate for any elective public office or position, or any other person within 3 months immediately preceding any election and within 1 month thereafter, without authority from the Commission on Election. Act as bodyguard or security guard for the person or property of any public official or private person unless approved by the proper authorities. Reveal secret or confidential police matters and information which jeopardize police mission and operations, or which cause injury or damage to citizens. Unauthorized establishment of checkpoints in any public thoroughfare for the purpose of stopping or searching vehicles or persons, or if authorized does not comply with the rules set by the PNP. Unauthorized escorting of any vehicle carrying highly dutiable or taxable goods, merchandise, appliances, or machinery. Failure to turn over to the police station within a reasonable period any apprehended or arrested person. Countermand any lawful order of the mayor, chief of police, or his superior officer. Perform the duties and functions of customs or immigration authorities without proper deputation in accordance with law. Escort or allow other members to escort detention prisoners outside the jail in order to attend a funeral, visit a sick relative, or solicit a bond without an order of the court of proper jurisdiction. Grave misconduct shall include but not limited to the following. Maltreat or abuse any prisoner or detained person under his custody. Receive for personal use of a fee, gift, or other valuable thing in the course of official duties or in connection therewith when such fee, gift, or other valuable thing is given by any person in the hope or expectation of receiving a favor or better treatment than that accorded to other persons, or committing acts punishable under the anti-graft laws. Join a strike or refuse to report for duty in order to secure charges in terms and conditions of his employment, or to oust the chief of police or any other officer from office. Contract loans of money or other property from persons with whom the PNP office has witness relations. Solicit or accept directly or indirectly any gift, gratuity, favor, entertainment, loan, or anything of monetary value which in the course of his official duties or in connection with any operation being regulated by, or any transaction which may be affected by the functions of his office. The propriety or impropriety of the foregoing shall be determined by its value, kinship, or relationship between the giver and receiver and the motivation. A thing of monetary value is one which is evidently or materially excessive by its very nature. Directly or indirectly have financial and material interest in any transaction requiring the approval of his office. Financial and material interest is defined as pecuniary or proprietary interest by which a person will gain or lose something. own, control, manage or accept employment as officer, employee, consultant, counsel, broker, agent, trustee, nominee in any private enterprise regulated, supervised, or licensed by his office, unless expressly allowed by law. Publicly consort with women of ill repute and or scandalously cohabit with or maintain a wife other than his legitimate spouse. Fail or refuse to surrender or deposit his service firearm, badge, identification card, and police vehicle, if any, to his superior officer upon demand during the period of suspension. Willful failure to pay just debts or obligation due to the government. Appropriate for his or allow another person the beneficial use of any stolen property that is recovered, found, or abandoned. Solicit money, valuable or favor for the amicable settlement of cases under investigation. Engage directly or indirectly in partisan political activities or take part in any election except to vote. Deliberately or through gross negligence, destroy, damage or lose government property entrusted to him for official use. Mutilate, deface, or destroy any driver's license, traffic citation ticket or temporary operator's permit issued in lieu thereof. Inflict physical injuries upon a suspect to force the latter to give a confession. Act as mediator or fixer for the return of any stolen vehicle or property whether held for ransom or not. Commit any act or omission that constitutes a crime punishable under the revised penal code or special laws where the duration of the imposable penalty is imprisonment of not lower than 6 months and 1 day. Grave dishonesty involves the presence of any one of the following attendant circumstances. A. The dishonest act caused serious damage and grave prejudice to the government. B. The respondent gravely abused his authority in order to commit the dishonest act. C. Where the respondent is an accountable officer, the dishonest act directly involves property, accountable forms or money for which he is directly accountable and the respondent shows an intent to commit material gain, graft and corruption. D. The dishonest act exhibits moral depravity on the part of the respondent. E. The respondent employed fraud or falsification of official documents in the commission of the dishonest act related to his or her employment. F. The dishonest act was committed several times or in various occasions. Or, G. The dishonest act involves a NAPOLCOM examination irregularity or fake NAPOLCOM eligibility such as impersonation, cheating and the like. Conduct unbecoming of a police officer as defined in Section 1, Item 5, of Rule 21. Incompetence as defined in Section 1, Item 6, of Rule 21. Oppression as defined in Section 1, Item 7, of Rule 21. Disloyalty to the government as defined in Section 1, Item 8, of Rule 21. Rule 22. Penalties. Section 1. Imposable penalties. The following are the penalties that may be imposed in police administrative cases. Reprimand. Withholding of privileges. Restriction to specified limits. Restrictive custody. Forfeiture of salary. Suspension. Any combination of penalties under Section 1, subparagraphs A to F, except E and F, which are incompatible penalties. 1. Rank demotion. Dismissal from the service. Section 2. Range of penalties. The penalties for light, less grave and grave offenses shall be made in accordance with the following ranges. For light offenses. Reprimand for the first offense. Withholding of privileges, restriction to specified limits, restrictive custody, suspension or forfeiture of salary, or any combination thereof from 1 day to 10 days, minimum. Withholding of privileges, restriction to specified limits, restrictive custody, suspension or forfeiture of salary, or any combination thereof from 11 days to 20 days, medium. Withholding of privileges, restriction to specified limits, restrictive custody, suspension or forfeiture of SA1 area, or any combination thereof from 21 days to 30 days, maximum. For less grave offenses. Withholding of privileges, restriction to specified limits, restrictive custody, suspension or forfeiture of salary, or any combination thereof from 31 days to 40 days, minimum. Withholding of privileges, restriction to specified limits, restrictive custody, suspension or forfeiture of Sala 1Y, or any combination thereof from 41 days to 50 days, medium. Withholding of privileges, restriction to specified limits, restrictive custody, suspension or forfeiture of SELA 1Y, or any combination thereof from 51 days to 59 days, maximum. For grave offenses. 60 days to 6 months suspension, minimum. 1 rank demotion, medium. Dismissal from the service, maximum. Section 3. Limitation in the imposition of penalties. In case of forfeiture of SELA 1Y, the amount shall not exceed the equivalent of 1 month salary. The penalty of withholding of privileges shall be confined to deferment of vacation leave privileges, participation in training grants or programs, and such other similar privileges normally enjoyed by civil service employees. Section 4. Mitigating and aggravating circumstances. In the determination of penalties to be imposed, the following circumstances shall be considered. Awards and commendations. Employment of fraudulent means to commit or conceal the offense. First offense. Good faith. Illness. Intoxication. Length of service in the government. Offense is committed during office hours. Offense is committed in consideration of a price or reward. Offense is committed in cooperation with two or more persons. Offense is committed within the premises of the government office or building. Recidivist. Repeatedly charged. Taking advantage of official position. Taking undue advantage of subordinate. Use of government property in the commission of the offense. Utilizing minor in the commission of the offense. When the victim is a minor, feeble-minded or physically disabled. Analogous circumstances. Section 5. Guidelines in the application of penalties. The imposition of the penalty shall be made in accordance with the manner herein below provided. Like penalties shall be imposed for like offenses, and only one penalty shall be imposed for each case. Each case means one administrative case which may involve one or more charges or counts. The minimum period of the penalty shall be imposed where only mitigating and no aggravating circumstances are present. The medium period of the penalty shall be imposed where no mitigating and aggravating circumstances are present. The maximum period of the penalty shall be imposed where only aggravating and no mitigating circumstances are present. Where aggravating and mitigating circumstances are present, Rule B shall be applied where there are more mitigating circumstances present. Rule C shall be applied where the circumstances equally offset each other. Rule D shall be applied when there are more aggravating circumstances. If the respondent is found guilty of two or more charges or counts, the penalty to be imposed should be that corresponding to the most serious charge or count, and the rest shall be considered as three gravating circumstances. In the appreciation of any mitigating circumstance in favor of the respondent, the same must be invoked by him, while any aggravating circumstance shall be considered against him if the same is alleged or pleaded by the party concerned. Otherwise, such circumstances shall not be considered in the determination of the penalty to be imposed. Section 6. Administrative disability inherent in certain penalties. The following are the administrative disabilities inherent in certain penalties. The penalty of dismissal, which results in the separation of the respondent from the service, shall carry with it that of cancellation of eligibility, forfeiture of retirement benefits, and the disqualification for re-employment in the government service. The penalty of demotion shall entail appointment to the next lower rank, regardless of mode of entry into the P&P, with the corresponding diminution of salary and disqualification for promotion and withholding of privileges for the calendar year. The penalty of suspension, which consists in the temporary separation or cessation of work of the respondent for the duration of the sanction, shall carry with it that of disqualification for promotion and withholding of privileges corresponding to the period of suspension. The penalty of forfeiture of salary, which consists of an amount not exceeding 1 month salary, shall carry with it that of disqualification for promotion corresponding to the period of the penalty imposed. Rule 23. Miscellaneous provisions. Section 1. Authority to administer oath. In addition to the officials who, under existing laws, are authorized to administer oaths, officers designated to conduct pre-charge investigation and summary hearing officers of the Commission, PNP, IAS, the chairman and members of the PLEB and regional appellate boards have the authority to administer oaths on matters connected with the performance of their duties. Section 2. Authority to issue subpoena ad testificandum and subpoena duces tecum. The disciplinary authorities, IAS, and their summary hearing officers shall have the authority to issue subpoena ad testificandum and subpoena duces tecum, only in relation to the investigation of the administrative cases assigned to them. Section 3. Monthly report. Within the first week of each month, all disciplinary authorities, IAS, and appellate bodies are required to submit a report for the preceding month to the regional office of the NAPOLCOM or the Commission N-Bank, furnishing a copy thereof their respective head of office, indicating the following data/information: a list of newly filed/received or raffled cases, revived, reinstated case, or cases transferred/referred or re-raffled from other office/officers. B. List of investigated, heard, resolved/decided, or pending cases. C. List of cases transferred/referred or re-raffled to other offices/officers stating clearly the reason for such transfer/referral or re-raffle. And D. List of cases with suspended proceedings stating clearly the reason for its suspension. Section 4. Effect of a pending case. Pendency of an administrative case before any of the administrative disciplinary authorities, 1AS or appellate body shall not be a bar to promotion nor a disqualification to undergo mandatory training. Section 5. Issuance of clearance/certification. Any disciplinary authority, IAS or appellate body or its authorized official upon written request and payment of the legal fee shall issue a clearance or certification indicating the pendency or non-pendency of an administrative case against any PNP member. The request shall contain the name of the requesting party, name of the police officer subject of the verification, and the purpose of the request. Section 6. Appearance and submission of pleadings by lawyers. The disciplinary authority or IAS shall require all the practicing lawyers to indicate in the pleadings filed before it the number and date of issue of their mandatory continuing legal education, MCLE, certificate of compliance or exemption as may be applicable pursuant to Bar Matter No. 1922 approved by the Supreme Court N-Bank in its resolution dated June 3, 2007. Failure to disclose the required information would cause the denial of further appearance and admission of the pleadings of the concerned lawyer. All government lawyers appearing before any disciplinary authority or IAS shall be required to present their authority to practice for the particular case for which they are entering their appearance. Otherwise, such appearance and any pleading submitted for any of the parties shall not be allowed. Rule 24. Transitory provisions. Section 1. Repealing clause. Memorandum Circular Numbers 93-024, 96-010, 98-014, 99-006, 99-014, 2002-010, 2002-013 and 2007-001 are repealed. All other NAPOLCOM issuances or portions thereof inconsistent with this Memorandum Circular are hereby superseded or modified accordingly. Section 2. Application to pending cases. These rules shall apply to pending administrative investigations/cases with the different disciplinary authorities, appellate bodies, and IAS insofar as practical or applicable, provided, however, that the offenses and penalties reclassified under these rules shall have retroactive effect insofar as they are favorable to the respondent. Section 3. Penal clause. Any public official or employee who violates any of the provisions in this circular shall be dealt with accordingly. Section 4. Separability clause. Any portion of this memorandum circular inconsistent with the organic law or declared unconstitutional shall not affect the validity of the other provisions. Section 5. Effectivity clause. This memorandum circular shall be effective after 15 days following the completion of its publication in at least two newspapers of general circulation nationwide.